Welcome to Legal Lines. This program is brought to you by the York County Bar Foundation. My name is Tom O'Shea, the host of this program, and my guest today is attorney Haley Rohrbaugh from CGA Law Firm. Welcome, Haley.
Welcome. Good afternoon.
And Haley practices in several different areas of law, but with a large focus on bankruptcy, correct?
Yes, sir.
And Haley actually came up with today's topic, which is the myths about bankruptcy. So first question, Haley, is why are you calling this the myths of bankruptcy?
Well, a lot of people don't understand what bankruptcy is, so they have a lot of misconceptions and misunderstandings about what happens in bankruptcy, what happens after bankruptcy, and there's a little bit of a bad stigma that goes along with it. So I'd like to clear up some of those questions that a lot of the clients have for us and concerns before they file.
And in preparation for this program, you gave me a list of the myths that you hear the most often. So what I'm going to do is read off the myths one by one and let you comment. And the first myth is everyone will know that I filed for bankruptcy.
Yeah, so it used to be that these were published in the newspaper. After the recession, it would have to be an encyclopedia every week to publish everyone who files. So they no longer publish in the newspaper, and unless the media picks it up, if it's a big corporation or a prominent figure, no one's going to know. I personally have to have a login that we pay for to be able to pull up bankruptcy filings.
All right, now, so let's... I didn't remember this, but at one time, you're saying that the local papers would publish a list of names of people who filed for bankruptcy?
Yes, sir.
I don't remember that, okay? But that no longer is the case.
No, sir.
And you said since the recession. Are you talking about the 2008 recession?
Yep, that's it.
So since that time, they no longer publish the names?
Nope.
But I am correct that it's a public record. If somebody wanted to look up who filed for bankruptcy, they would be able to do so.
Absolutely. But like I said, I have a login, and really anyone who's looking into a bankruptcy filing would be a creditor or one of the credit bureaus. Really no other person in your life, none of your friends or family are going to be jumping onto Pacer to check that.
When you say a login, what does that mean?
There is a website where I can search for any filing in the entire country.
When you say I can, why is that?
Because I have a login.
Okay.
So anyone, it's going to be bankruptcy attorneys. A lot of people at the firm come to me to check to see if someone has filed in any state before they try to collect against them.
Right. But so could anybody get a login?
You have to pay for it. So
if
no
somebody
one wants it.
really wants to, they'd have to pay a fee to be able to log in to get the information over the computer. Otherwise, they'd have to go up to Harrisburg or where the bankruptcy court is and check the docket up there.
Yeah, I don't even know if they'd be able to do that without paying a fee.
Oh, I don't know. But the bottom line is that this is not something that anybody's going to know unless they go out of the way to try to find out.
Absolutely.
So and as you pointed out, if some big company files for bankruptcy or some politician files for bankruptcy, that might
The
be...
media would pick up on that.
Pick up on
Yeah.
that. Okay, the second myth that we have here is all debts are wiped out in Chapter 7 bankruptcy.
Yes, so there are several types of debts that are not dischargeable, which most student loans, most government debts, so any type of income tax, real estate tax, those types of things.
Let me ask this to get really down to the basics. You said a Chapter 7 bankruptcy. What does that mean?
Chapter 7 bankruptcy is liquidation. That means you give everything up and you get rid of all of your debt. You don't have payments. It's over in about 3 to 4 months. You have to qualify for a Chapter 7 because that's really the ideal goal if you're going to file bankruptcy, is start over completely fresh after a few months. There are income requirements and there are equity and asset requirements. If you have too much or if you make too much, you're not going to qualify for a Chapter 7.
So there are income guidelines as to whether someone could qualify for a Chapter 7.
Yes.
Okay? And that's as opposed to a Chapter 13 where you have to have a repayment plan.
Absolutely. Now, some people choose to be in Chapter 13. I'll get into it a little bit more later, but if someone's fallen behind on mortgage payments, income tax payments, real estate tax payments, those are all things that are not dischargeable, but we can cure them through a Chapter 13 plan. Let me take that back. Mortgages, they're completely dischargeable if you surrender them. You can't continue to live in a house and not pay for it.
Right.
So those are things we can cure through a Chapter 13 plan. Now that lasts over 3 to 5 years, so a little bit more commitment than
But
a 7.
the Chapter 7, I think you used the term a liquidation bankruptcy. In other words, take my assets, it's not enough to pay all my debts, but take what you can.
Yep.
Whatever I can't pay, I don't have to pay anymore, and I have my fresh start.
Absolutely. Now, one little caveat with that is good for debtors is that there are a certain amount of exemptions that
And that's
they can
your next
protect
myth.
their
Your next
stuff.
myth is, I will lose everything I own if I file for bankruptcy.
Yes, so that's a big myth, and everyone thinks that. You will lose everything you own. But most people don't have enough, if they're doing Chapter 7, to have to give anything up. So, for example, in Pennsylvania, we can use federal exemptions. You get about $12,000 in household goods, your tables, your chairs, that type of thing. You get $23,000 and change for equity in your home. Most people, especially if they're filing Chapter 7, are going to be underwater or not even own a home. So there are certain exemptions that will protect people's things.
Is there one for a vehicle?
There are vehicle exemptions. You get about $3,600 per person. Again, not a lot of people have a paid-off vehicle, and if it's paid off, it's $2,000. You know, it's not worth anything.
So, to begin with, for most people, unless they have some very unusual antiques or expensive jewelry or artwork, their household furnishings are not going to be touched.
Absolutely.
Okay, so they'll keep their furniture, they'll keep basically everything they have inside their house.
Absolutely. Now, it is an opportunity to get out of some things. So if they want to get rid of their house with the mortgage on it that's underwater, they can just surrender it, walk away.
But if they have less than $23,000 worth of equity, am I correct, if it's a married couple that's filing jointly, that would be $46,000 worth of equity?
Yes, that's per person are the exemptions. So joint filers will double that.
So if a married couple has a house where they have less than $46,000 worth of equity, they would be able to keep that house and not have it as part of what gets liquidated to pay their debt.
Absolutely. If they have more than that, they have the option of paying the value of that equity rather than giving up their house. So they could do it one of two ways. Pay the value or just walk away from the house.
And to determine the equity, there'd have to be a fair appraisal on the house.
Yeah, we get comparative market analyses done for Chapter 7s. They're typically free. Realtors do them for free. If it was an issue and we were really close to that $46,000, we'd then opt for an official appraisal.
Okay, and so then you would look at what's owed on the mortgage.
Yeah.
Now, I am correct that you still have to pay that mortgage if you're going to keep the house.
Absolutely.
You can't discharge that mortgage.
No, you cannot.
And then when we talked about the vehicles, same thing holds. You said, what was the dollar amount on a vehicle?
Now, we'll say $3,700. It's $3,685 or something like that.
All right, so if I had a vehicle that was worth less than that, I could just keep it. If I had a vehicle that was worth more than that, but I had a loan against the vehicle, after I subtract the loan, if there's less than $37,000, whatever, I'd be able to keep that vehicle if I agree to keep paying the car loan.
Absolutely. Now, there are also things we can do for people who are underwater on their houses and their car loans. The car loans, we call it a redemption. You just pay what it's worth. So if someone owes $20,000 on a car that's worth $8,000, we can pay the creditor $8,000. And in a Chapter 7, you have to come up with that in one lump sum. In a 13, you can pay it off through your plan. houses underwater, we can completely remove the second mortgage. So that's a huge benefit. That would be dischargeable.
So here again, back to the myth, I will lose everything. It's possible with some expertise that somebody who owns a house, owns a vehicle, has furniture, can keep all those things and still be discharged of their credit card debt and other debt that they might have.
Absolutely. So a lot of times we file bankruptcy so that people can keep their stuff and that they don't lose it to a repossession or foreclosure.
But there are some strict rules on how much that's worth, so they better see an attorney who knows what she's doing.
Yes.
If they want to try to go the Chapter 7 route and keep some of their items. By the way, for people who don't own a house, is there an amount of cash that people can keep?
Yeah, if you don't own a house, that is just your wild card exemption. We call it the D5 because of where it is in the bankruptcy code. That will increase. You get more of the wild card that you can apply to whatever you have, basically.
About how much money is that?
I think it's about $12,000.
So if I owned no car and I owned no house, but I had $12,000 in the bank,
yeah.
I could leave the bankruptcy still keeping my $12,000 and have the debts just discharged.
Absolutely. Absolutely.
Okay. So really, it's for some people they could walk away from the bankruptcy with significant amount of money or significant amount of asset.
Absolutely. The goal is to give them a fresh start. So once they see me the initial time for the initial consultation, they should walk out that day in a better position. Because at that point, if we've decided to file bankruptcy, they'll stop paying the creditors who will be discharged. So that first day after the initial consultation, they're already starting toward their fresh start.
Okay. And then the next myth is, I'll never get credit again.
Yeah, they'd be surprised. People who file get credit card offers pretty much immediately because you can't file and get another discharge for a certain period of time. It's either 4, 6, or 8 years, depending on which chapter you're going from to which chapter. FHA loans, you can get an FHA mortgage 2 to 3 years after your discharge.
That means after the bankruptcy's over.
Yes. Car loans, we get them for people in bankruptcy all the time when they need
You'll see television commercials where they advertise that they'll give you a car loan if you're in bankruptcy.
Yeah, absolutely. And I know someone personally who's a miracle worker getting people into cars.
So, and one of the things that I will tell people when they say, well, I don't want to go bankrupt because it could ruin my credit, is you're in so much debt right now that you don't have credit anyway. And most likely, if you didn't have all this debt, a lender would look at you more favorably if you went bankrupt than to lend you money now with all this debt because they'll think you're going to file for bankruptcy any day.
You're absolutely right about that. And we have in our software program, we pull credit reports and it gives an analysis of 15 months post-bankruptcy and everyone's credit score has jumped 30, 40, 50 points because that debt to income ratio goes down. You clear out all your debt, you really have no debt to income ratio.
And
there.
You can't go bankrupt again for another, 7 years?
It's, 8 would be the complete liquidation discharge.
Okay. And we're out of time for our first segment, but we'll be back with more myths about bankruptcy. Welcome back to Legal Lines. My guest today is attorney Haley Rohrbaugh from CGA Law Firm in York, and the topic is the myths about bankruptcy. In our first segment, we talked about several of the common myths with bankruptcy and had Haley set us straight, and we'll go on to the next item on the list, which is it's really hard to file for bankruptcy.
Oh my, no, that's an absolute myth. If you get a good attorney, if you get a good law firm, because we do all of the work for you. We give you a little bit of initial homework. You need to fill out a worksheet that tells us some of your personal information, and then we take it from there. You only show up one time, and you go to a trustee, and he asks you questions for a few minutes. One of the questions sometimes is, have you won the lottery since you filed bankruptcy? So we get a kick out of it, actually. It's kind of, it's very hands-off for the debtors. We do everything for you down at the firm.
But with it doing everything, you still need the information from the person filing for bankruptcy as to who to contact with respect to their debts.
We pull credit reports.
Oh.
So typically, we only need to know if there are medical bills out there that aren't on the credit reports. We search prothonotary for any types of lawsuits.
I wouldn't even need to give you my credit card numbers or the addresses for the credit card companies. You'd be able to get that from the credit report and then notify the creditors that way.
Absolutely. There's not a lot that we need from the debtors. They can provide us with pay stubs so that we can calculate their income. They provide us with a list of expenses, list of household goods, but there's not much that they have to do on their own. We do a lot of the work here in the office.
Okay. The next myth, only deadbeats file for bankruptcy.
That deadbeats don't get to file for bankruptcy. The bankruptcy code literally says it is for the honest but unfortunate debtor. There are code sections that keep deadbeats from filing. They call them serial filers, and people who incur debt via fraud and other situations are not going to get a discharge of those debts.
So, I realize that there might be many, many reasons why somebody needs to file for bankruptcy, but what are the most common situations?
Medical issues are huge. Loss of job, that's a big one that we don't see as often anymore, but during the recession and all the layoffs, that was the main reason. Any type of big life change, increasing your family by having another child, splitting your family is a big one. Family law and bankruptcy go hand in hand a lot of times.
So in a divorce situation, the husband and wife with two incomes might have supported the house and all their bills, but if they're going to maintain two separate houses, the bills they had before might not get paid.
Yeah, and actually in a divorce situation, sometimes the debts aren't dischargeable if they are ordered to be paid by the court. So if both spouses are filing, it's a little different.
Okay, and that goes to the next myth. If I'm married, my spouse has to join me in the bankruptcy.
Yeah, not necessarily. A lot of married couples, especially if one's a business owner, will have most of the debts in only one of the spouse's names. We get to, actually, in that case, if we file bankruptcy for one spouse, we get to use all of the other spouse's debt payments, and it decreases that disposable income at the end of the month. If both spouses filed, we can't use those debt payments in their expense list because those are going away. We're discharging those. So we like to see when only one spouse is able to file so that the other one keeps the bankruptcy off of their credit report, and just it's easier for them, I think, if one spouse is the filer.
Okay. Now, if one spouse is the filer and we're talking about a Chapter 7, it might limit the amount that they can exempt from the bankruptcy.
Yeah, and actually, one thing I didn't want to get into earlier was that Pennsylvania is a tenancy by the entirety state. So if one spouse was filing, we would look to see if the Pennsylvania exemptions on the real estate were more beneficial to use, because we can, they could have a paid off house worth $150,000. If one spouse isn't filing, we use the tenancy by the entirety exemption and protect that entire piece of real estate. We're not confined to only $23,000.
So that's why it's important to see a good bankruptcy attorney. But what you're telling me is, if let's say one spouse has tons of credit card debt, but they own their house jointly with their spouse, tenancy by the entireties, as you stated. They own the house together. And there's well over, $46,000 worth of equity. They could have a $150,000 house without a mortgage.
Yeah.
Because the house belongs to the party that's not filing for bankruptcy,
Yep.
the bankruptcy court can't do anything with the house, and they can still discharge the credit card debt of the spouse who has the credit card
Yep,
debt.
exactly. And what the bankruptcy court will do, they'll ask for a copy of the credit report to make sure that all of those debts are only in the one spouse's name. If there are a couple of small ones, we will advise the couple to pay off those before the bankruptcy for the one spouse is filed, so that they can take advantage of the tenancy by the entirety exemption.
And tenancy by the entireties, if I remember from law school, which was many, many years ago, basically says that the marital unit owns the property as opposed to the husband owning 50% and the wife owning 50%. So therefore, the courts cannot sever the marital unit in the absence of a divorce. The marital unit owns it, and therefore creditors for one can't attach both.
That is absolutely correct. And that's not the case in every state. I did bankruptcy in Florida. They don't have a tenancy by the entirety exemption. So that's where you need to be careful.
So even though bankruptcy is a federal law, when it comes to the exemptions, they have to follow the state law.
Depends on what state you're in. In Pennsylvania, we've opted to use federal exemptions or state exemptions. So we can analyze the case and choose which one would be better.
Okay, but in some states you can't do that.
Yeah, some states require you to use the state exemptions only.
Okay, I'm going to your next myth about bankruptcy. I don't have to include all of my creditors when I file for bankruptcy.
You do have to include everyone you owe when you file. Unfortunately, some people owe family members and friends. We have to list them. There are some things that we can do to maybe work out some debts before they file, but you have to be careful with preferential payments. You can't pay one creditor off and not pay the rest of the creditors, say your mom. You can't pay her off, or the bankruptcy court will go after that creditor, get the money back, and disperse it evenly among the creditors.
So if a month before filing for bankruptcy I decide to pay back the loan my brother gave me,
Can't do that.
what would happen if that occurred?
We would have to disclose it if it was over $600. And the trustee who oversees the creditors and the debtors makes sure we're all doing what we're supposed to. He would actually go after your brother and get that money back. He would demand it back, or he'd have to sue him. Once he got it back, he could disperse it pro rata among the remaining creditors.
I see. So that's known as a preference. And is there a gap of time that they look at to see whether or not there was a preference being made?
Typically 90 days.
Okay. In other words, they'll look at what you paid back in the last 90 days.
Yep.
And this is to prevent people from picking and choosing who they want to pay back and who they don't want to pay back.
Absolutely.
Okay. The next myth, you can't get rid of back income taxes through bankruptcy.
Yeah, okay, so you can't discharge income taxes, but if you're not filing bankruptcy, you're going to pay whatever bill they send you with interest and penalties. When you file and we pay it back through a Chapter 13 plan, the IRS, for example, will bifurcate their claim into 3 different types of claims, if applicable. It will be an general unsecured claim, secured claim, and priority unsecured claim. The only portions that you have to pay back are the priority and secured. Oftentimes, they will have a significant portion of your income tax as a general unsecured debt, and general unsecured debts are dischargeable. So, for example, I have a client recently who owed about $25,000 to the IRS. We put him into a Chapter 13, and he's only ending up paying back about $12,000 because of how they bifurcated the claim. So outside of bankruptcy, you can't get out of your income tax. There are certain situations where you may be able to settle or make a payment plan, but that's not likely outside of bankruptcy. So you do get a benefit on your income taxes if you file.
Okay, so I see that the myth is that, and this is what I always thought it was, that the IRS, you owe the IRS, you can't file for bankruptcy and discharge that debt. And that is true.
That is true on the priority portion of the claim, or the secured portion if you have enough stuff that they have filed a federal tax lien on your house. That's something that needs to be paid back.
Okay, but there might be ways to reduce the amount that you owe to the IRS through bankruptcy.
Yep, absolutely.
Okay. There are other debts that cannot be discharged. Am I correct?
Yeah.
The most common that I hear is student loans.
Student loans. Now, there are certain situations where those are dischargeable, and actually our software program that we have at the firm will automatically analyze your student loans and let us know if there's something we need to look into, if possibly one would qualify. So the most common would be if you're disabled, unable to get a job, but you really have to be in an extreme situation to not pay those student loans back. Private student loans that are above the straight tuition, so extra living expenses, those types of things, that's what our software program analyzes. If you have any of those out there, those types of student loans are dischargeable. Most people have Stafford loans through the government, though, which are not. But we also do help people apply for income-based repayments or talk to them about, I guess, more affordable ways to pay their student loans.
Okay. Next myth. You can only file for bankruptcy once.
Oh, that's not true. Now, they don't like serial filers, but from a Chapter 13 to a Chapter 13, you only have to wait for 4 years. From a Chapter 13 from a Chapter 7 to a Chapter 13, you only have to wait 6 years. And from a 7 to a 7, you wait 8 years. That's because the 7 is, you're not paying anything. You're getting out of everything completely. So yeah, you can file every 4, 6, or 8 years, depending on what your situation is.
Depending on the type of bankruptcy. So it is something that can be done in the future. Not that you want to be in that situation, but it could occur, and you're not prohibited from 10 years from now from filing for bankruptcy again.
Yeah, and most people, after they've been through it once, they realize it's not devastating to your life. It's not this, it's actually very helpful. It's a good program for the honest but unfortunate debtor.
The whole goal is to give people a fresh start.
Absolutely.
Okay, and the last thing that we only have a little time left for, is it a good idea to max out my credit cards and then file for bankruptcy?
I won't file a bankruptcy for you if you do that.
That would be known as fraud.
Yes.
and people should not commit fraud. They could get in trouble with the bankruptcy court. And with that, we're almost out of time. Thank you, Haley, for being our guest. Our guest today was Haley Rohrbaugh from CGA Law Firm. This is Legal Lines, brought to you by the York County Bar Foundation. Thank you for watching.